this all started for us at CAPI when we were asked by District Attorney Cy Vance to do an independent review and report and recommendations about campaign finance donation acceptance practices. As I'm sure you all know, back in the fall there were press reports about the decision not to prosecute Harvey Weinstein in an alleged groping incident and the decision not to charge,
There it is. Good.
not to charge the two of the Trump children, Ivanka and Don Jr., with fraud relating to the Trump Soho project. And then some diligent investigative reporters learned that lawyers for those people had given campaign donations to Vance's campaign and said that there may have been a connection between the donation and the decision. So as all of that was going on, DA Vance decided to ask us to do this independent review, which we did. And we realized a few things right off the bat. One, we started thinking about what this problem was. And it can be a variety of things, right? It can be an actual corruption problem. You actually could have real corruption with giving a donation and then there being a quid pro quo decision, right? You also could have just an unconscious bias problem where you're getting donations from people, you know about those donations, they then come in on cases and you don't even really realize it, but you're kind of favoring them in some manner because you know they're donors to you. And then you could have, a very clearly, you're really not considering donations at all in making your decisions, but there's a perceived problem, right, of the type that the press identified in this case, where DA Vance said those donations had nothing to do with his decision making, he wasn't even really aware that they had come in and so on, but still the press identified a problem and he got a lot of bad press about it for a while. So those are the potential issues you're talking about. And the problem is exacerbated because district attorneys have so much discretion and so much of what they do, of course, is behind closed doors for good reason. You don't want targets of investigation to be hearing that they're under investigation. That's not fair to them. And if they're never charged, they would never want their names to be out there. So this decision making is necessarily a confidential process. Not to mention grand jury secrecy rules and all of that. But that leads to a lack of transparency that leads some folks to be skeptical of the bases for the decisions. It's also exacerbated by the fact that donation limits, as they relate to district attorneys, are so high. In the city, donation limits are quite low, but strangely, DAs are kind of in this netherworld between the city and the state. They're county-wide officials, but for purposes of their campaign donation limits, they are governed by the state election laws. And the limits are quite high. There's a formula counting active voters, 5 cents a head, but in any event, for the big counties like Manhattan, Brooklyn, Queens, it's close to $50,000. So I think for the last general election for DA Vance, the limit was in the high 40,000s. So one person can give that much money. That's a lot of money. If it were a few $100s, you would say, even if people are giving that and then appearing in front of the DA, it's not enough money to look suspicious or make a difference, right? $40-some thousand is a lot of money. So that's another reason that this is a problem that we thought needed to be addressed. Donations need to be reported. State Board of Elections site contains lists of all donations over $100, I think. So people can go on and see who's giving to these candidates. So we also learned that, as I mentioned before, there's no real guidance in this area. You obviously have the donation limits, you have some election laws, but as far as kind of as an ethics matter, what DAs should be doing, how they should be considering this problem of actual potential perceived conflicts of interest, there's nothing out there, nothing from the bar associations, nothing from the District Attorneys Association. It's really left to individual DAs, if they recognize that this is a potential problem, to do something about it and to do it voluntarily. So, we found some very general guidance on things like, prosecutors should act with good faith. Prosecutors should avoid conflicts of interest generally, but really nothing when it comes to campaign donations at all, which made it challenging. So what we did when we got this assignment was to, of course, do all of this research to try to see whether there were models out there, whether anyone had passed regulations that related to this, and they had not. We did look at what applies to judges in New York State, which I'll talk about in a minute when I turn to the recommendations, the blinding provisions where judges are not supposed to know who their donors are. So there are those provisions and regulations, but nothing that applied to elected prosecutors. So we just started talking to people. We spoke to lots of folks, including many DAs around the state. There's a list in the appendix, one of the appendices of our report, thanking and listing the folks that we talked to, just to get their ideas, try to learn something about their practices, and kind of bounce ideas off them about which of our recommendations they thought would work and that they might even be willing to implement. We also tried to crunch some numbers using some information that we got from the Manhattan DA's office and also the publicly available information from the State Board of Elections website. We really just wanted to know, when you look at someone's donations, how many of those people giving are lawyers, how many do we think are criminal defense lawyers. So we're trying really to identify the subset of people who might actually be in front of the office doing business with the office, because those were the people who we thought were problematic when it comes to potential conflicts of interest.